Good morning or afternoon or evening for those who are joining us today for this discussion on the impacts of the pandemic, the COVID-19 pandemic, on the administration of justice. My name is John Packer. I'm the director of the Human Rights Research and Education Center at the University of Ottawa. And I'm delighted to be able to invite you and host you today on this panel. We are honored to have the United Nations Special Rapporteur on the independence of judges and lawyers, Diego Garcia Sayan, who's a longtime associate friend and an extremely distinguished international jurist. Who has, for most of you, I'm sure, needs no introduction, has a remarkable list of achievements, which I'm not now going to read. You can Google Mr. Garcia Sayan for all of his many governmental, intergovernmental, and non-governmental roles and achievements. And our discussion will be joined by others, but let me also not be remiss by failing to acknowledge that I am speaking to you today, as are some of my colleagues at the University of Ottawa from unceded and unsurrendered Indigenous lands, which here in Ottawa, what is contemporarily called Ottawa, has yet to be negotiated with the Indigenous peoples, and we are cognizant of that. So without further ado, we have an interesting session. This relates to the work that Mr. Garcia Sayan has done as the UN Special Rapporteur and in his role for the UN Human Rights Council with the active support and engagement of our Human Rights Clinic, which is directed by Salvador Herencia Carrasco, and with the project coordination by Dr. Jordi Valero Fio. And so we will hear some views later from them. But without further ado, I invite the Special Rapporteur to comment on the subject. Let me also draw your attention that there is simultaneous interpretation available. For those of you who wish, you can just check through the Zoom function, and you will be able to click on the language of your preference. So Diego, please enlighten us.
Yeah, Diego, if you don't mind, before you start, so just I'm going to be moderating in a way the discussions and the questions.
My apologies. I should have signaled that Salvador.
No worries, John. No worries.
Moderating the discussion. My role was just to provide some welcoming remarks, and I'm sorry that I skipped directly to the main event.
No worries, no worries. We're actually in good time. So again, once again, welcome everybody, and thank you for joining us for this event. At first, we're going to have the UN Special Rapporteur, who will present for about 15 to 20 minutes, the main findings and the conclusions regarding his report to the Human Rights Council on the impact of the pandemic to the administration and independence of judges of the judicial system. After his presentation, we will host Ursula Indacochea and Jordi Feo Valero for comments. It will be 10 minutes each, approximately, so that we can leave a good 15 to 20 minutes for a discussion. As John mentioned, we have interpretation, so I would please, French interpretation, I would like to please try to speak slowly so that our interpreters can do the best job possible. And in advance to all the attendees, I invite you to submit some questions on the chat, so in a way we can get as much discussion as possible. So, as John said, Diego Garcia Sayan is one of the most important jurists from Latin America. He has held many positions, including Minister of Foreign Affairs, Minister of Justice. He was a judge and president of the Inter-American Court of Human Rights before being elected as appointed as UN Special Rapporteur on the independence of judges and lawyers. He's a fellow Peruvian like me, and my de facto boss for almost 20 years now. So this is how far we go way back. Anyway, so Diego, it is great to have you here with us, and you have the floor.
Great, thank you, Salvador, and thank you, John, for the very generous presentation that you both have made, and really my deep appreciation for the Human Rights Clinic and for the University of Ottawa for the systematic support that this humble special rapporteur has received in the last years. Without this support, considering the weakness of the support that UN bureaucracy gives, it will be very, very difficult to have achieved a lot of activities that we have been able to perform in the last years. One of them, the most recent, at the beginning of this year, actually at the end of this year, was to check what was going on with justice and the coronavirus disease, COVID-19. The first reaction of some frozen bureaucrats that was a useless thing to consider, but that considering that that pandemic would finish soon, and there will be nothing to speak about it in the following months or in the year 2021. It was obvious that they were wrong. The World Health Organization had distributed a lot of views and analysis about the deepness of this challenge to humankind, and so here I am sharing with you some conclusions and some recommendations of the report we presented to the Human Rights Council in the month of June this year, and that has generated a lot of positive debate and positive reactions. Because as you all know, the coronavirus disease, COVID-19 pandemic, has not only taken the life of more than 4 million people, but it has severely undermined the functioning of the judicial systems, increasing the risk that the states will be left without a functioning, accessible, and independent system of justice. Its impact, of course, has been uneven, differing from country to country, but has tended to be disproportionately severe for vulnerable groups and women, in a context of increased violence against women, in which figures almost in every country show the dramatic increase in violence against women, domestic violence, or other sorts of violence, in a context in which in some countries there was no judicial system, efficient judicial system available to complain or to present their drama. To obtain input for that report, a questionnaire calling for contribution was sent to states, international and human rights organizations, professional associations of judges and lawyers, and civil society organizations. A fantastic figure of 73 responses were received, not a usual amount of responses, because many people just assume that the special rapporteur is informed of everything, but actually that the specific contributions are essential for preparing a report. And this was an unprecedented undertaking that underscores the importance of addressing the issue in a special report to the Human Rights Council and the impact of the pandemic in the justice system and independence of judges. I wish to express my special thanks and appreciation to the Human Rights Clinic of the Human Rights Research and Education Center at the University of Ottawa for the considerable support it provided for the preparation of the present report. My deep appreciation to Salvador Herencia and to Jordi Feo Valero would never be enough to express my gratitude to what the Human Rights Clinic and what Salvador and Jordi are doing and will be doing in the following months, I'm sure. There are several conclusions in the report whose content I won't summarize here, but I have chosen 6 conclusions that in a way illustrate very concisely the essential components of this report. The first one, the impact of the pandemic on individuals, institutions, and societies is unprecedented. Many courageous individuals working in the justice systems or in relation to them have paid with their own lives to continue performing their duties with dedication during the pandemic. My special gratitude and homage to hundreds of judges, prosecutors, lawyers, and administration personnel from the judicial systems that have got sick and or have passed away, unfortunately, after the impact of the pandemic. Second, lockdowns and isolations and social distancing measures have affected the work of the courts and have led to delays in proceedings and the suspension of procedural deadlines and the provision of legal assistance. Closure of courts, the prolongation of pretrial detention, the non-execution of court orders, or the suspension of trials have had a negative impact on fundamental rights worldwide. The administration of justice was rarely considered within these restrictive conditions as an essential public service, which is really a pity. Third, gender-based violence has been a particular concern, as an exponential increase in domestic violence against women and children has been observed when quarantine, confinement, and other restrictive measures are taken. While some countries have designed and implemented special procedures and remedies for women and children who feel threatened or affected, these have been unfortunately insufficient. Fourth, prison overcrowding affects human rights in all circumstances, but it is still being particularly serious in the context of the pandemic, as it exponentially increases the risk of contagion among prisoners and prison staff. In a number of countries, a high proportion of persons deprived of liberty are being held in pretrial detention. The media in Latin America, for instance, is about 50% of the prison population in pretrial detention, contributing unnecessarily to prison overcrowding and seriously impacting the health condition of detainees in prisons. Fifth conclusion, innovation and teleworking have become permanent features of the working environment in judicial systems. The use of virtual means for various types of legal proceedings has provided a positive response to widespread and prolonged judicial paralysis. However, there are unanswered questions about guarantees of access to justice, due process, and judicial guarantees in relation to the use of digital communication tools. The design of such technology for virtual meetings may on occasion undermine the confidentiality between legal counsel and clients, or may influence testimonies or expert statements given virtually, in which it's very difficult to check if a witness is being advised by a person that we are not able to see or hear through Zoom or other similar mechanisms. Sixth and last conclusion in this summary of much more conclusions that are written in the report, the digital divide, a crucial matter right now in the world. Difficulties or impossibility in accessing the internet and some forms of information technology make it especially challenging to ensure equitable access to technology, and the lack of training for operators and users, which gravely undermines access to justice. As a result, many people, including members of the legal profession in several countries, have been left particularly exposed to difficulties in defending or upholding rights. Then I want to share with you some recommendations that are included in the report, in which I have extracted 4 of them. Countries must consider the situation caused by COVID-19 as an opportunity not only a problem, but an opportunity to avoid public policies that ensure the independence, to adopt public policies that ensure the independence and effective functioning of justice systems and that facilitate people's access to justice with a gender perspective and with respect for human rights. In development such policies, states should be guided by the international human rights treaties and standards, established, for instance, and especially first in the basic principles on the independence of the judiciary adopted by the UN in 1985, the guidelines on the role of prosecutors adopted by the UN in 1990, and finally, the basic principles for the role of lawyers adopted at the UN in 1990 as well. 4 key recommendations that I want to share with you that can be, of course, enriched by Jordi's or Ursula's comments and by the questions of all. First, the justice system should be considered an essential public service and its personnel should be considered as essential personnel not only during pandemics, but including them in the context of vaccination processes, which are still an ongoing matter in most countries in the world. Of course, additional budgetary resources are required for this, which is not necessarily the case, unfortunately, in most countries. Second, countries should take necessary steps to prioritize criminal situations that have increased exponentially during the pandemic. Special emphasis should be placed on gender-based violence, domestic violence, and corruption. I have mentioned some aspects of gender-based violence and domestic violence, and especially I want to add that the concern that corruption as a threat occupies a kind of priority in the attention of judiciaries in this context of crisis. Billionaires of corruption is a wording I have heard in some countries in Africa or in Latin America because additional resources allocated by the states are not necessarily used or expended with transparency and with appropriate orientation. As a special rapporteur, I have called and continue to call the states to strengthen means of prevention and care for victims of domestic violence, gender-based violence, in cases of investigation of systematic corruption, especially transnational corruption. Third conclusion, justice systems are resuming full operations. In many cases, they have already resumed. They will need to adapt and plan their activity to take into account not only the accumulated backlog, but also the new workload arising from the changing pattern of some of the illicit behaviors that emerged during the pandemic. It is imperative that the courts have sufficient resources, again, to ensure the proper administration of justice. And fourth, last but not least, digital divide is a crucial component in the recommendations and should be a crucial aspect in the agenda of judiciaries and governments around the world. 3 crucial aspects to consider related to the digital divide. First, countries must take prompt and sustained actions to close the digital divides that affect access to justice and generates exclusion. The states should promote appropriate policies to achieve universal access to the internet and information technology that bridge the digital divide and ensure real and effective access to justice by guaranteeing connectivity and the availability of the necessary software and equipment, as well as adequate training. Consideration should be given to developing accessible and differentiated information for vulnerable groups. Second, countries should provide tax and fiscal incentives to boost private and public investments, both to increase broadband and 5G supply and to subsidize internet and 5G access in the poorest sectors, including, for instance, infrastructure sharing between companies, which is a crucial component so to avoid additional expenses. The opportunity cost is much more efficient and cheaper than expanding or upgrading the road network, for instance. Widespread 5G in first and second tier urban centers according to World Bank estimates, would cost in each country 0.17% of GDP per year, much less than the several percentage points of investments that are required in transportation or energy. And third, the technology used in providing judicial services should ensure respect for privacy, confidentiality, and security for the information transmitted. The privacy of attorney-client interaction must be strictly enforced through appropriate programs and mechanisms that are to be built by engineers or specialized people in this area, which is not necessarily the case when we communicate with programs like Zoom. It's a new challenge for technicians and a new challenge for companies, but all this should be promoted and guided by states. So when the pandemic seems to begin to relax, no? Not only new challenges have appeared after the impact of the pandemic, but new ideas, new suggestions. So we should see this tragedy, of course, not only as a dramatic process, not as only as a very negative period in which many colleagues have received the impact of the pandemic, but as a big opportunity to establish appropriate and fluent communication between societies and the judicial system. Of course, all of this guided, as I have mentioned, in the principles established by the UN, in which in all of these situations, independence of the judicial system should be the kind of guide star to orient all the policies in this dramatic moment. So that would be a kind of brief summary of the conclusions and recommendations, and it will be absolutely fantastic. All the comments and ideas that two persons as specialized and consistent like Ursula and Jordi will share with us right now. Thank you very much for your attention.
Thank you very much, Diego, for your presentation. I have included in the chat the link to the report, and it's available in all 5 official languages of the UN. So we are now, before we go into the comments section, I would like to invite everybody for your questions and comments to start making them, put them in the chat or on the Q&A section. And it is my absolute pleasure now to welcome Ursula Indacochea. She is the program director on judicial independence for the Due Process of Law Foundation, which is a Washington-based NGO working on human rights and rule of law and democracy in the Americas. And the LinkedIn says that she is a lawyer from the Pontificia Universidad Católica del Perú with a master's at the same university. So she's also a fellow Peruvian. She has previously worked as a fellow at the Inter-American Commission on Human Rights on the program related to human rights defenders. But what LinkedIn doesn't say is that Ursula is perhaps one of the most relevant experts on the issue of independence of judges and lawyers, appointment of judges, especially at high courts in the Americas. So for us, it is an absolute pleasure to welcome Ursula here with us. And please, Ursula, tiene usted la palabra. Muchas gracias.
Thank you, Salvador. Well, good morning, everybody. Thank you, Salvador, for your words. I'm very touched for them. First of all, I would like to thank the Human Rights Research and Education Center for the invitation to share this panel with the Rapporteur Garcia Sayan and Professor Feo, and to give me the opportunity to make some comments on the report presented by the Rapporteur on the topic of justice and the pandemic, an issue that we have followed from DPLF since the pandemic started. I was planning my comments and I wanted to divide this into some initial considerations, general considerations, and then I would like to comment on some focus and emphasis of the report that resounded a lot to me as they are innovative. And finally, I would like to have a brief comment on the challenges for justice in the context of the pandemic in Latin America, especially considering a general, I don't want to be pessimist, but deterioration of the democracies in our region. First, I would like to start by saying that the topic of the report is of an absolute relevance for us. At the Due Process of Law Foundation, as Salvador mentioned, where I serve as the Director of Judicial Independence, we noticed that the impact of the pandemic on justice systems in Latin America, that where our work is focused, and together with various civil society organizations, we decided to monitor the situation more closely. And at the end of 2020, we requested and were granted a thematic hearing on this issue before the Inter-American Commission of Human Rights that you can find in their YouTube channel if you want to dig more into it. But the first thing we noticed from all these monitoring efforts joined was the absolute invisibilization of the justice in the public agenda of the pandemic. The attention of the governments in the early stages of the pandemic was on the control of international and national mobility, in the enforcement of the containment measures, the distribution of food in some cases. And later, the concern moved to the economic reactivation, reassumption of schools and education, management of the vaccination processes. But justice has never been, and nor is it, in the public agenda of the pandemic as an essential service. So this is extremely worrying, concerning, and we found it difficult to understand, given the importance of justice to control the measures adopted by governments, especially at the early stages of the pandemic, measures that were taken in exercise of extraordinary powers that their constitutional charts granted them, but also to protect human rights and liberty of the citizens. So for us, it was difficult to understand how justice was not on the spot. Of course, this is why the rapporteur's first statement in April 2020 was very relevant, and then it was followed by this report, and also by a joint statement with the Inter-American Commission of Human Rights on this issue that emphasized the access to justice, because the topic of justice and the pandemic is very broad and has a lot of issues into it, but the access of justice was the one that was emphasized in these early pronouncements. So we think that the report was very timely. The report itself says, well, there are some challenges that will pass, but others will stay. And the reality has certainly confirmed that. And the report emphasizes in several occasions, and it's funny that the rapporteur and I, we decided that there was a coincidence in the aspect that we wanted to emphasize that the justice is an essential service, and therefore that the suspension of justice services must be subject to strict scrutiny, and that its continuity must be guaranteed to the greatest extent possible during any state of emergency, including pandemics. So placing justice in the public agenda of the pandemic has specific consequences. It's not just a declaration. The main consequence is that it will require a diagnosis of the situations and the needs to be met, and then to formulate strategies to address those problems, and also the allocation of material and human resources, and also, of course, evaluation of those strategies. But the report documents exactly the opposite, that some countries reduce the budget allocations for justice system. So let's move to the focus and the emphasis of the report. The rapporteur correctly identifies three major dimensions that are affected by the COVID pandemic: the functioning of the justice system, the accessibility of the justice system, and the independence of the justice system. I don't want to go into detail on each of these, since the rapporteur has already explained some of the contents, but I would like to highlight some of the emphasis of the reports in each one of these dimensions, which I thought are novel and important. Let's start with the first that has to do with the functioning. The first has to do with the planning of justice services. The report specifically mentions that there is a significant backlog of cases that is impossible to quantify. We have noticed that in most of the Latin American countries where we have monitored the situation, and also that the pandemic has generated a new backlog as a result of the suspension of judicial services and new situations that have increased exponentially that have to be addressed. It's not only new things that already existed, that now that the suspension have been ended are coming into the justice system. There are also new kinds of conflicts, or conflicts that have been increased. For example, the things that have to be with family law, for example. That could be a good example. With all the diseases of the pandemic, there's a lot of civil issues that have to be addressed by the justice system. So it's very important that there's a procedural discharge plan, and that the justice services come into a rationalization. But this has to be transparent and respect the standards of judicial independence and human rights. So for me, this is a very novel contribution, because given the magnitude of the problem here, the rapporteur warned that it's not a simple matter of administrative management this here. It's an issue that has a direct impact on the rights of people. And this implies that this planning has to be taken in a transparent manner, but also considering the process, the voices of judges and employees of the justice system, and also the final recipients of the justice services and the citizens. The second emphasis is linked to the access to justice. The report refers in detail to situations and problems of very specific groups, as women or persons deprived of liberty. And this report advocates to find solutions that are specifically focused on these groups, but also in general to groups that are vulnerable, or people that are vulnerable as a result of the pandemic. I think here it's appropriate to recall that access to justice not only implies that the states have to not put obstacles to justice, but also to remove those that already exist, and also, if it's necessary, to modify the domestic laws and institutions to make justice accessible to anyone. So I think in this case, the digital gap is one of the issues, but not the only one. I think that the access to justice is gonna be the center, or should be the center of the focus of any judicial policies in the future, as there are a lot of demands to be met, especially for those who most need it. And finally, the third emphasis has to do with the independence, and the report highlights two situations that we have also identified. That during the pandemic, there were threats and criminalization of judges and also prosecutors, especially those who dare to put limits to the measures of the, especially executive powers. You know, those who protected the rights and liberties of people, of citizens, who said, well, these people should be released, but because you cannot deprive them of liberty just because they were in the street at the time where the measures that you adopted said that they would be at home. You cannot take them and imprison them for that. And those judges were criminalized, and there are so many cases in the region. We have them in El Salvador, in Guatemala, in Bolivia, in Chile also. And the reports mention also what happened about the pending selection and appointment processes of high judicial authorities during the pandemic. And this is very important because there were several, and the limitation of mobility gave more space for, at the opposite, gave less space for citizen scrutiny. And that was in a way taking as an advantage for people who wanted to manipulate those processes. So it was a special concern of us. We have a still pending process in Guatemala to elect all the members of the Courts of Appeals and Supreme Court, and as well in Peru, the Constitutional Court. I don't remember right now that if there are others pending, but it's a very important issue that in this context, we should assure citizen participation and transparency on these processes. And I cannot skip to mention a particular concern on transparency and accountability of justice systems, as it is linked to my previous commentary. During the pandemic, we found that a lot of requests of access to information presented before courts and prosecutor general's offices were not being responded, or also that the information about how the courts were functioning were not clearly and timely publicized and disseminated. So transparency, it's transversal, but it's also very important to remember that the justice courts and the justice system not only has to be independent, but also has to be accountable for what they do. And finally, I would like to remember the importance of a gender perspective on this. The report has it, as it highlights the situation of women that were victims of violence, but also we have to remember the female judges and the female magistrates that are inside working within the systems, and that have specific situations that have to be addressed in the policies that the justice systems adopted to face the new situation. Teleworking affects women, female judges in a different way that it does to their male peers. So let's not forget about them. My final very brief comment on what's going on and what's the future of this in Latin America has to do with the crisis, the democratic crisis that we're viewing in different countries. I wouldn't say that there's a cause effect relation here and that the pandemic caused this, because the causes are more deep. But certainly the challenges are big because the pandemic in general has created a special environment that favors authoritarianism. And to face and to contend these authoritarianisms, we need strong judiciaries. And certainly the judicial system has been weakened on purpose or not by the pandemic, or also by the governments of those countries. So we need to remember that it's crucial to strengthen them, not only to face this post-pandemic situation, but also to in a way safeguard democracies in our region. So I would stop there and thank you very much for listening.
Thank you very much, Ursula, for your words. And just in case you were wondering what country she was talking about, you can look up a president whose bio right now is the coolest dictator in the world. So this is the situation, and this is what the threats to the judiciary and independence of judiciary, and how seriously these new autocrats are taking into regards to the protection of human rights and rule of law. So now it is my pleasure to welcome my esteemed colleague and friend, Dr. Jordi Feo Valero. He did his PhD at the University of Valencia, and he has written extensively about human rights, independence of judiciary, and rule of law in different journals in Latin America and abroad. But he's also a Human Rights Research and Education Fellow, and he is director of the project supporting the mandate of the UN Special Rapporteur. So Jordi, thank you once again. He's not Peruvian, he's Spanish, okay? and it is our pleasure to welcome you, and thank you for being here with us, Jordi.
Thank you very much, Salvador. Good morning, ladies and gentlemen. Bonjour, madame et monsieur. I'm gonna do my presentation in English, but feel free to ask your question in French if you prefer. I'll be glad to answer them in that language. Thank you very much for being here today with us. First of all, I would like to thank the UN Special Rapporteur, Mr. Diego García Sayán, and the Human Rights Research and Education Center, the University of Ottawa, for the invitation to participate in this webinar. Please, before I address the matter in hand, allow me to say a few words about our project at the clinic. As you know, my name is Jordi Feo. I began my collaboration with the Human Rights Research and Education Center in 2017, when I was appointed as visiting researcher, and later in 2020 as fellow. Since 2017, I have been working as the coordinator of the project Independence, Judges and Lawyers at the Human Rights Clinic under the direction of Mr. Erezzi. The aim of the project is to provide research support to the UN Special Rapporteur, focusing on the thematic reports that must be submitted every year to the Human Rights Council and the UN's General Assembly. So far, I have had the honor to work with the Special Rapporteur in every report he has presented since 2017. The experience and knowledge acquired over these years is an asset that will accompany us until the end of our professional career. The following presentation is divided into two parts. First, I will briefly outline the main practical challenges that the Rapporteur support team has faced in contributing to this report. And then I will highlight some contents that, as a human rights clinic, we consider particularly important. Due to the novelty of the subject, the information on which this report had to be based was scattered or simply non-existent. In collaboration with the Office of the United Nations High Commissioner for Human Rights in Geneva, and under the direction of the Special Rapporteur, rigorous research work was carried out to identify the main elements needed for the report. Once the Special Rapporteur identified the key areas where information was missing, a questionnaire calling for contribution was prepared and sent to states, international, regional human rights bodies, professional associations of judges and lawyers, and civil society organizations in order to fill up the gaps and address the threats. As the Special Rapporteur said, a total of 73 responses were received. This was an unprecedented undertaking and a major challenge for the Special Rapporteur and his team. The large number of contributions received underscored the necessity of addressing the issue in a report. Once the documentation was received, the information was analyzed and divided into two blocks: answers from the states and every other group. Regarding the documentation sent by the states, the Special Rapporteur had to analyze it, cross-check it, and identify those trends that were repeated in different regions of the world, as well as their exceptions. On the other hand, As expected, the information obtained from the responses of international and regional human rights bodies, professional associations of judges and lawyers, and civil society organizations provided the rapporteurship with a much more critical view of the impact of the pandemic on the administration of justice. I don't know if you are familiar with the elaboration of this kind of report. I would just like to point out that the length of such a document cannot exceed 11,000 words. That's around 21 pages. You can imagine how difficult it was for the special rapporteur to summarize the information received in so few pages and present it in an attractive and understandable way. As the UN Special Rapporteur acknowledged in his report, the pandemic of COVID-19 has severely undermined the functioning of judicial systems. Its impact on institutional societies has been unprecedented. Many states suspended, interrupted, or expanded procedural deadlines, and courts have to prioritize certain matters. In general, states were not prepared for the widespread court closures and did not have regulations in place to govern access to justice. As a human rights clinic, we are very concerned about the influence that the pandemic has had on the rights and freedoms of vulnerable groups. The fact that the justice gap could be increasing for these groups is an element that we cannot ignore. Our main concern, therefore, is how to ensure the full enjoyment of human rights and prevent such situations in the future. The Special Rapporteur pointed out how the pandemic has increased the risk that some states will be left without functioning, accessible, and independent system of justice. Its impact on the administration of justice during the pandemic has been uneven, differing from country to country. The research revealed that the effects have tended to be disproportionately severe for vulnerable groups. It is therefore particularly important to assess the extent to which vulnerable groups have had the right to access to justice restricted. During the pandemic, courts have to provide uninterrupted access in urgent legal matters, particularly for vulnerable people in cases of domestic violence, traffic of human beings, detention and torture-related situations, and remedy for cases emerging from excessive or discriminatory emergency measures. Even where the courts remained open they worked with limited capacity. Physical access to court buildings were restricted significantly in many places. Consequently, individuals faced considerable challenges in access to justice in civil, criminal, and administrative processes. The report has shown how judicial systems have responded to a limited degree to the need to make organizational changes and innovations that allow for specific responses to provide for the additional exigencies of vulnerable groups in much the same way as health systems have done. According to international organizations like the Office for Democratic Institutions and Human Rights of the Organization for Security and Cooperation in Europe, or UN Women, access to justice for some vulnerable groups reportedly fell by 66% during the pandemic. In this regard, it should be noted that groups such as victims of human trafficking, people at risk of suffering gender-based violence, prison population, persons without legal identification documents, or good quality internet access, among others, have been particularly affected with regard to their access to the judicial system. The European Commission for Efficiency and Justice has noted that it is worth keeping in mind principles of flexibility, dialogue, innovation, and concern for the needs and situation of vulnerable groups. Judicial systems must guarantee security and privacy while avoiding the imposition of procedures that are excessively rigid or formalistic or necessarily restrictive in terms of the technology required. Such procedures could create obstacles for and have discriminatory effects on the most vulnerable and isolated sectors of the population. During the pandemic, not many countries adopted differential approach to narrow the digital divide in judicial services, affecting the most vulnerable groups. It is important in the interest of preventing the widening of the digital divide between groups, countries, and regions to ensure broad access to the new technology. There is thus an obligation to develop national, regional, and global initiatives aimed at bringing the appropriate technology to the places and groups that needed it, and to train people in how to use it. When addressing that issue, the needs of vulnerable persons in accessing and managing the technology must be considered. Some good practices have been documented. For example, in countries such as Guatemala, Guyana, and Rwanda, computers were placed in a number of public spaces to ensure that persons belonging to disadvantaged groups had access to electronic means during the pandemic. In Ecuador, campaigns were run to inform the public of ways to gain access to justice online. It is very important that when designing their protocols and responses to pandemics, courts consider the need of vulnerable persons and the impact on their rights to a fair trial and access to justice. The prioritization of cases following the end of emergency measures should ensure gender equality and the protection of the most vulnerable, including children, older persons, and persons with disability. The mistakes have already been made, and in view of the situations that have arisen, there is little or nothing we can do about the past. However, there is one thing we can do. We can learn from our mistakes in order to improve the situation of those groups that have been left behind during the management of the pandemic by these states. It will be unforgivable if we were to repeat the same mistakes again in the future. Thank you very much. Merci beaucoup pour votre attention.
Thank you very much, Jordi, for your comments, and thank you also again to Ursula and to everybody that is here with us. We have approximately 10-15 minutes to respect everyone's time for some questions and comments. So perhaps I could give the floor to Professor Packer so that he can share an initial comment and thought. And please don't be shy. Share with us your comments, your questions about this very important topic. John, please.
Thank you, Salvador. I'm just checking that in terms of the participants, they also are aware that there is the Q&A in the from the chat, which I think is possibly disabled. There's a Q&A, so not to hesitate to pose those questions. I wanted to ask about, if I might, just by way of kicking off a little exchange around the positive impact of the coronavirus in terms of technology, because, for example, in Canada here, for the first couple of months, the courts and similar bodies almost ground to a halt. There was a kind of feeling, oh, we can't meet, it's dangerous, and so forth. And then there was a sudden realization that, of course, we could meet through technological means, as we are meeting now. And this then became adopted and now has essentially been institutionalized with also an investment of modern technology, but in fact, just a kind of change of practice and a customization or acclimatization of the professions. And it's been to the betterment of the administration of justice. It's accessible, it's quicker, it's much cheaper. So, for example, lawyers don't have to charge an appearance fee and so forth. I just wonder, in your observation and how you see this from a positive perspective, not just all the daunting elements and the ways in which you've already discussed. Of course, I asked that directly to Diego, but I invite also Ursula or Jordi to comment.
Okay, no, really very important comment, John, because really, so to emphasize the need to have a big decisions regarding digital divide, perhaps I have not stated very clearly that as well, this is a fantastic opportunity, because several hearings that are taking place, not only with an additional expenditure for lawyers, but without additional loss of time in big urban places in which it takes several, not only minutes, but hours eventually to reach the judicial places, in which if all the parties do not participate, eventually a new date is fixed. No, so it is a fantastic opportunity when the digital means are accessible, and as well in areas of the world in which the fanatism for punctuality is not one of the major characteristics. It is fantastic that these hearings, they begin on time, absolutely on time in all cases, and if they don't begin on time, they won't take place, which is a kind of new ingredient for local culture in several parts of the world. But at the same time, you have the reality that in not only in rural areas, no, but even in big urban areas, the lack of resources for families, even for lawyers, no, impedes that they may have a working computer, that they may have an accessible internet. So the kind of social inequalities can be easily expressed in this matter. The ideas I was sharing is that really to close the digital divide is not a question of magic, not a question of resources that you need to build the Aswan Dam again, but a percentage that has been already fixed by the World Bank, which is 0.17 of GNP annually, which is, of course, 0.17 is some money, but not thing that will limit the government's plan regarding roads or sewage system. So that is a feasible view. And of course, that will require new technologies and agreements to promote public and private investment, which is perfectly feasible. But this requires political decisions, require clear guidelines from the states. My feeling is that these guidelines won't come from the judiciaries themselves, because there's a kind of reluctance to change in the judiciaries and institutional bodies all around the world. So these new changes in which if they already have a computer, they feel that they are already modern. That depends. And of course, that is a challenge as well for AI techniques, because we need new technological procedures. So to deal with hearings in which the lawyer should be in contact with his or her client without the interference from the other parties, which is a thing that can be done now, excepting with the people have a phone to speak with their client, but that doesn't work usually when the people are in prison. No? So in a way, that's a technological aspect as well. But finally, to hear the positive and negative things, I think this opens a fantastic challenge. But this would require big political decisions, and of course, if possible, some guidance as well by the judiciaries and the high courts and whoever is in charge of the administration or management of courts in each country.
Before I give Jordi and Ursula perhaps the word for them to expand, but following up on this, I mean, the report that you've presented to the Human Rights Council identified the gaps and the challenges, right? But it takes not only political effort, but also a lot of resources and leadership. So considering that we are in Canada, or this is mostly a Canadian audience, what do you think, what would you expect or wish to countries like Canada that have a full commitment on human rights, rule of law, to actually help, advance many of this, the challenges and recommendations that you have presented? So this is like perhaps an open, parallel question, but also to hear from Jordi and Ursula as well.
Yes.
Before Ursula and Jordi, that I am sure they will have much more consistent and broad ideas. I imagine now the idea that eventually the university or the center can promote a kind of meeting between AI technologies and technicians to discuss what will be the main challenges, to have the appropriate mechanisms to guide the parties in judicial processes. And second, eventually to promote a meeting with technicians of the World Bank and some specialized components of the main judicial bodies in whatever area of the world. I would prefer, of course, Latin America, to discuss what would be the budgetary consequences of a challenging program of 5-10 years to close the digital divide. That would be a fantastic component to support context in which the administration in the judiciaries in each country in Latin America, for instance, are more allocated how to deal with a big mess they have to solve in the day-to-day life without major changes because they don't have the budget to do so. So this gap eventually could be helped to close. No? That would be a first reaction or comment to your reaction to your comment, Salvador.
Sorry. Go ahead, please, Ursula.
To add to what to the answer, I was actually doing some research before the pandemic started about major judicial reforms and with a focus on digitalization. And I was there's a very good book on that made by UNODC that documents different processes around the world. And I discovered that it's not only like that you have to open an email account to receive the lawsuits or the requests. It implies a long time. You need to simplify your processes. You need to do legal reform, maybe to simplify those. And then you need a lot of resources, as Dio said, a lot of commitment of the top authorities that normally, you know, the presidents of the judiciary, maybe they're not, maybe it's something generational, but not necessarily are familiar with the technology or open to understand the needs in all the countries at the same level. So it needs political commitment, a lot of resources and funding in a long term. And it's not that easy, but as Diego said, this pandemic forced states to start that on going on that direction, because otherwise they just cannot fulfill their mandates. So whether they don't, if they don't have the will to do it, now they are forced to. So that, I think that is a positive thing. But of course, in that process, you have to think about how to reach all the people who need most the justice, people who are exactly those who before the pandemic were not able to have justice. There are millions of people in the globe that cannot have access to justice services, and that number, I think, has increased during the pandemic.
Thank you. I just wanted to point out something about the report. The report has shown that there has been a very difference facing between the states which had already with online systems used on a regular basis prior to the COVID-19 and those who not. You cannot imagine. I mean, it's not the same being in Norway in pandemic situation that being, for example, in a country like Haiti. For the use of technology in judicial sphere requires not only the ability to access electronic means and the technological know-how, but the training of those who have to use it. So that's very important, as the state need to allocate a budget and a means to implement it. And not every country has the means to implement the budget, even if they do have the money. That's a thing that we must take into account. Thank you.
Thank you very much, Jordi. And so we have one comment from John. that said, that there is an effort within the G7 countries to build back a better world, and how this initiative, right, can also include the administration of justice to, facilitate access to justice while respecting principal human rights. But also there's a comment from our colleague from the PhD program here at Ottawa U, Vinicius, that's saying that there are discussions regarding the administration of justice outside the UN and the OAS or the European system. So he mentions the Ibero-American Judicial Summit, who are dear friends of the rapporteur. So he's asking what are the challenges, that are being discussed within these other branches regarding the impact of COVID to the administration of justice.
Well, to be frank, I am not aware of what is being discussed in the Ibero-American Summit. No? Perhaps there are important things. I am sure that is being proposed and discussed. I am aware that, for instance, UNESCO is promoting big discussions about AI and the connection with administration of justice, which is a very positive component. And so, in any case, there's the need to a sort of I won't say the word leadership, because that would undermine eventually the capacity to call different organizations, but to coordinate and to ask them just to share what they are thinking about this. So I'm sure that the Ibero-American group, perhaps they are discussing this matter. I know that the UNESCO is discussing the matter of AI technology. The World Bank has some views about how to improve and how to close the digital divide. And in this context, I would imagine that academic bodies may have easier and more expeditive way to call for meetings and for debates, this kind of organizations in which they won't feel that they will be swallowed by other intergovernmental organizations, if that is the case. But my feeling is that more interaction, more sharing of information is deeply needed in this context.
Thank you very much, Diego. So we've pretty much come to the end of this webinar. So before I give Professor Packer the possibility to conclude and to thank our speaker and participants, I just wanted to highlight how this report was not only timely. It was 73, I think, Jordi, reports or submissions that we got from institutions and states all over the world, which is, I think, it has been by a landslide the largest number of contributions that the UN Special Rapporteur has received for a thematic report. So this is the importance of the needs and the issues of inequalities that we're discussing on COVID have to have the administration of justice at the core of these discussions, with the participations of those involved. As a future activity, the Special Rapporteur he submitted to the UN General Assembly that started this week his new report, which is a byproduct of this report on the pandemic, focusing on the participation of women on high courts and prosecutorial offices in the world. And we hope to have a presentation of this report during the days of in the mark of the campaign of the 16 days of activism against gender-based violence. So we look forward to seeing all of you again in the late November, for where the rapporteur will kindly present the report that is very important to us. Is very important, especially for countries like Canada with its foreign policy regarding rights of women. So again, from my end, Diego, as always, is a great pleasure to see you. And Ursula, thank you very much. This is your home, Ursula. Whenever you want, we are always at your disposal. Jordi, needless to say. And so, John, please.
Thank you, Salvador, for those final comments. And just let me take a moment to thank again our panelists, contributors, above all, Diego Garcia Sayan, for your not only constant confidence in us as we support you, and the great honor of the recognition you bestow upon the work of the center, led by Salvador and Jordi, and with the students' active involvement now over a number of years. Let me underline, it's an honor. It's really an honor for us as at the University of Ottawa, at the Human Rights Research and Education Center, and through our clinic, to be able to work with you, to learn from you, to follow the path that you lead in the as a special rapporteur, but in your wider professional life, in support of the fair, equal, and reliable administration of justice and the rule of law, protection of human rights. So thank you for that. Thank you also, Ursula. Nice to, we haven't met. It's a nice opportunity to connect, but certainly we are grateful for the ongoing collaboration with the Due Process of Law Foundation and the work that you and your colleagues have done and allow us to do with you. And then let me also thank Jordi for your very specific engagements and assistance over these number of years, and that we are able to continue to work. And let me thank those who have attended, viewed, participated. Let me finally just say that this is an event in the context of our 40th anniversary of the Human Rights Research and Education Center, established in 1981. It was, to my knowledge, one of the very first dedicated human rights centers in the world, called the Human Rights Center, established with the specific objective of bringing human rights and drawing international human rights protections into the Canadian Constitution, which was achieved through the Charter of Rights and Freedoms in the Canadian Patriotic Constitution of 1982, something we will celebrate later and reflect upon critically later this year. But just to say that these opportunities to study, engage, and to apply human rights norms and values are precious, and we will continue to, Diego, you may rely upon us to continue to provide with enthusiasm all of our support for important work and to work together with our partners in the hemisphere and beyond. Thank you to everyone, and have a pleasant rest of your day wherever you may find you.
Thank you.
Thank you.
Thank you very much.
Muchas gracias a todos. Thank you. Hasta
Gracias.
luego.
Thank
Abrazo.
Hasta luego.